Yes, welcome to all. I see the numbers still rising, so we'll just give it one more minute or so, and then we begin this webinar. Yes, well, the numbers seem stagnant now, so I suggest we start with the webinar. So good morning, good afternoon, or good night. I even saw that one name joined from Australia, so I think it's probably nighttime there. But anyhow, welcome to all. It's nice to see so many familiar names as well as new ones. Well, this is the seventh webinar that we're organizing, but it happens to be the first one dealing with international law, the sea, which is more my bread and butter. Well, I'm very happy to be joined by an excellent panel of speakers. I will introduce them in more depth prior to their presentation, but we have Professor Cavunelli from the University of Athens. We have Dr. Devani from the University of Glasgow, and we have Dr. Honeyball from the Max Planck Institute at Heidelberg. So briefly on the format. So we will be having 3 presentations. Prior to each presentation, I will join the panelists shortly, and then the speaker will have approximately 20 minutes or so to give his or her presentation. Once the presentations are completed, the floor will be open for discussion. So if you do have any questions, do put them in the Q&A box. I will moderate them, and then at the very end, I will put those questions to the different speakers. It would be useful if you do have a question that you indicate to whom it is directed. If it's directed to the panel in general, it would be fine as well. But that would make my life a bit more easy. So the topic of this webinar, you should probably already all know, is going to be the Enrica Lexie Award. And I think we celebrated its first anniversary quite recently. But we're going to revisit the Enrica Lexie Award because it has generated quite a lot of academic debate. It has generated quite a lot of criticism. And I think, at least I know that 2 of the speakers are probably going to be quite critical of certain aspects of the award. But we will try to give a very broad coverage of the issues involved. I assume most of you are familiar with the facts. Italian Marines shot 2 innocent Indian fishermen. They unfortunately died. The Marines were arrested by the Indian Navy, I think ultimately in the Territorial Sea. But I think Aaron will address this topic in greater detail. But like I said, and as mentioned, we will look at various topics related to the award. So I think James will focus more extensively on the issue of incidental jurisdiction and incidental questions. Aaron will look at the issue of flexible jurisdiction, particularly issues that arise with regard to Article 92 of the Law of the Sea Convention. I think Maria will bring it all a bit together and reflect on the case more generally. So without further ado, I would like to start with Dr. Devani, who will kick off the session. So very briefly on James, he's a lecturer at the University of Glasgow. He has published very widely on different areas of international law. His monograph on fact-finding before the International Court of Justice was published by Cambridge University Press in 2016. I think he also has a case note forthcoming on the Enrica Lexie case he co-authored with Professor Toms, who was not able to join us, but I'm very confident that James is going to be an excellent replacement for him. And as mentioned, he will focus on incidental questions, jurisdiction. James, the floor is all yours. Thank you.
Thank you very much, Yuri, for the invitation and to the interest group to speak to you today about what I think is a really fascinating award, and one which really merits revisiting. I'm going to share my screen with you just now, seeing as Yuri asked me to very briefly go over the facts of the case. I'm sure that most people are by now really well aware of the facts of the case, but maybe some of you aren't, and maybe it's been a while since some of you have thought about Enrica Lexie. So before I get on to discussing Enrica Lexie's sortie into the murky waters of the law on incidental questions and legal reasoning and legal justification, I will give a very brief, and I would stress very rough overview of the facts of the case, just to refresh our memories. So the dispute centers around the Enrica Lexie, that time an Italian flagged oil tanker, and the St. Anthony Indian flagged fishing vessel. And the Enrica Lexie was traveling between Singapore and Egypt when on the 15th of February 2012, in passing through India's exclusive economic zone, it found itself on a collision course with the St. Anthony. This area had been designated as an area at risk of piracy in the past, although I think quite significantly not on that particular day. But the Enrica Lexie was carrying a vessel protection detachment of Italian Marines designed to protect the vessel, as the name suggests, against such things as pirate attacks. And finding itself on a collision course with the St. Anthony, suspicions were aroused upon board of the Enrica Lexie that it may be under pirate attack. They at least perceived themselves to be. Attempts were made to contact the St. Anthony. No radio contact was established. And as the two vessels continued on their collision course, eventually a number of procedures were taken, including the firing of some warning shots. And then eventually the two of the Italian Marines opened fire with live munitions on the St. Anthony, killing two of the Indian fishermen before the captain of the St. Anthony was able to reach the controls and to take the St. Anthony off of the collision course. The Enrica Lexie carried on its original course. The St. Anthony messaged to the Indian Coast Guard to dispatch some Coast Guard vessels to intercept the Enrica Lexie, and it was persuaded to turn into the Indian port of Kochi. There, the two Italian Marines that you see here, Massimiliano Latorre and Salvatore Girone, were arrested. And it was the arrest of these Italian Marines that's really at the heart of the dispute between Italy and India, which makes up the Enrica Lexie case. And that was the basis of the award that we are revisiting here today. So that's my very brief and rough recap of the facts, sort of off the top of my head. Now on to the law. So the main findings, in my opinion, of the award, which was handed down on the 21st of May, 2020, were that both Italy and India had the concurrent jurisdiction over the incident. The tribunal had incidental jurisdiction over the question of the immunity of the Marines. The Marines themselves enjoyed immunity as state officials, but India was nevertheless entitled to compensation for the loss of life, physical harm, damage to property, and moral harm. Now, as you might expect, the award was more positively received by Italy than India, but there has been so far as I'm aware, no suggestion of non-compliance from the parties. Okay, so I'm going to talk about incidental jurisdiction over the question of the immunity of the Marines, it's maybe worth pointing out that the immunity question comes up on a number of occasions. So first of all, when the tribunal was looking at whether it had jurisdiction over the dispute itself between Italy and India, of course, it had to establish that it had jurisdiction under Article 2881, so only over disputes which concern the interpretation or application of UNCLOS. Italy, for its part, argued that the real issue in the case was which state had jurisdiction over the incident under UNCLOS, whereas India said that the real subject matter of the dispute was whether the Marines were entitled to immunity from criminal proceedings, a question that India said was not covered under Article 2881. And the tribunal on this point over jurisdiction over the dispute sided with Italy, saying that the dispute may raise, but is not limited to the question of the immunity of the Marines, and as such, it had jurisdiction over the dispute as a whole. So just to point this out, to flag the importance, again, I think we see this increasingly, and we've seen it in a number of recent cases, of the characterization of the dispute. My focus here on the question of incidental jurisdiction is going to be on one of Italy's claims in particular, namely the claim that India had violated the immunity of the Italian Marines. Now, of course, immunity is an issue which is ostensibly out with the scope of UNCLOS. However, Italy claimed that a number of provisions of UNCLOS brought the question of immunity within the jurisdiction of the tribunal by renvoi. However, the tribunal didn't accept these arguments related to any specific provisions of UNCLOS. Nevertheless, it did find an alternative way of bringing the question of the immunity of the Marines within its jurisdiction. What was that alternative way? Well, the tribunal said that Italy's claims could not be satisfactorily answered without addressing the question of the immunity of the Marines. It decided that the exercise of jurisdiction encompasses, but is not conclusively answered by, the question of the Marines' immunity, which it classified as being just one aspect out of several, albeit an important one, that requires examination in resolving the parties' dispute. And as a result, the tribunal found that in order to provide what it called a complete answer to the question of which party was entitled to exercise jurisdiction, it was necessary to examine the question of the immunity of the Marines. So how did it do this? Well, the tribunal relied on the notion of considering immunity to be an incidental question, and it cited the permanent court's dictum in certain German interests in order to uphold that it had jurisdiction to determine the question of immunity. I think this, though, raises the question of whether, in seeking to offer a complete answer, as the tribunal stipulated, it actually overstepped the limits of its jurisdiction under Article 2881 of UNCLOS. So, some thoughts then on the tribunal's resort to the doctrine of incidental questions. First of these thoughts is that, sorry, I just see a question in the chat. Can I just check that everyone can see the slides? Yeah, Maria, you can see them? Okay, great. So first of the thoughts then is that the reasoning that the tribunal offered for its resort to the doctrine of incidental questions in order to bring the issue of the immunity of the Marines within its jurisdiction was really justified in a rather sparse manner. The tribunal dealt with this issue in just 5 short paragraphs. it didn't justify its approach to any great extent. And this was an issue which was strongly criticized by Judge Robinson in his dissenting opinion and Dr. Rao in his concurring and dissenting opinion. And commentators, as Yuri alluded to earlier, have been similarly critical of this aspect of the award. Let's think a bit then about the doctrine of incidental questions itself. It is, as I mentioned, a long-established doctrine. We can point back to the PCIJ and we can say, okay, it has a long pedigree, but I would actually suggest that it's a rather underdeveloped doctrine. And as a result, the tribunal's sort of summary treatment of this issue stands out to me, as does its failure to engage with recent relevant practice. So for example, Shagos MPA award, it also touched on the issue of incidental questions, finding that the jurisdiction under Article 281 extends to ancillary determinations of law as are necessary to resolve the dispute presented to it. And in doing so, it adopted a two-part test. First of all, the question must be necessary to resolve the dispute, which does fall within the court's or tribunal's jurisdiction. And secondly, that the question must be ancillary in the sense that they must necessarily be determined in order to answer the real issue in the case, but it must not itself constitute or be part of the real issue in the case. The Enrica Lexie Award in those 5 short paragraphs only focused on the necessity criterion and didn't say anything about this second step, about whether in order for a question to be considered incidental, it had to be ancillary, or whether it had to be part of the real issue in the case. In only focusing in this sort of abbreviated manner on the necessity criterion, the Enrica Lexie Tribunal avoided a number of difficult questions, such as, was the immunity of the Marines really incidental or ancillary, or was it rather the real issue at the heart of the dispute? In that vein, the tribunal would have had to consider the more general question of what makes a question incidental or ancillary. Similarly, against which normative yardstick are future tribunals to measure whether they have jurisdiction over an incident as an incidental question? Are there certain questions which lend themselves to being considered incidental more than others, such as immunity or responsibility? I think this is, again, a very interesting question, but one which the tribunal had nothing to say, and so on. The point being that in offering this rather abbreviated reasoning, we don't really know. The tribunal avoided answering any of these questions. Further thoughts. In choosing to provide this complete answer, it does seem that the tribunal has accorded significant weight to the principle of effectiveness, right? It didn't want to offer a partial answer, it wanted to offer a complete answer. And the way that it thought it could go about doing so was through considering the immunity of the Marines to be an incidental question, even where this required the tribunal to interpret its own competence quite expansively. We should note that other courts and tribunals and recent awards and decisions of other courts and tribunals have struck a different balance, one which does not focus so much on effectiveness, but rather more emphasizes the role of the consent of states. And here we can look, for example, at 2 relatively recent cases of the ICJ, in the immunities in criminal proceedings case and the certain Iranian assets case, where the ICJ struck a balance which was more in favor of the consent of states rather than effectiveness. And also another Annex 7 tribunal in Ukraine against Russia, of course, in which the tribunal upheld Russia's preliminary objections relating to the territorial dispute, since this was not incidental, but rather central to the dispute between the parties. So the approach of the tribunal in the Enrica Lexie award, I would suggest, tells us something about how the tribunal sees its role or saw its role not only as a legal means of settling the dispute before it, but also as an actor in the international legal order. Now, on this point, and sort of taking a step back, do we think that the tribunal made the right decision here? I would suggest probably yes, right? Immunity is so rarely mentioned explicitly in framework conventions such as UNCLOS. I think the alternative, saying that this was not an issue which would fall within the jurisdiction of the tribunal, would have been much less satisfactory. However, I would argue that the authority of these tribunals is undermined by any sort of failure to provide fuller reasoning and justification for doing so. Of course, Annex 7 tribunals have some content independent authority by their very nature of existing as under UNCLOS as a treaty and as part of the Part 15 dispute settlement apparatus. However, the awards of these tribunals do also have content-dependent authority, and I would argue that this authority is undermined by a failure to provide full reasoning and justification for their legal findings. On this point then, this got me thinking, what would a more satisfying reasoning have looked like in this case? And here I think the work of Neil McCormick is potentially useful for us in thinking through how, even if we agree with the decision of the tribunal, how it could have been better justified. Now, McCormick said that legal decision makers are under a duty to do justice according to law, and to give only decisions that can be justified by a good justificatory argument. In certain straightforward cases where there's a clearly applicable rule agreed by the parties, the facts are agreed or settled, a decision could simply be justified by a straightforward deductive argument, application of the law to the facts. However, I think clearly this is not the case in relation to the Enrica Lexie award. In this case, in order to justify what the tribunal wanted to do, to provide a complete answer, to find out that immunity was an incidental question, this was not simply a case of syllogistically applying the law to the facts. Rather, in order to properly justify what it did, I would argue, drawing on McCormick, that it was important for the tribunal to also look beyond the rules and to consider second-order justifications. So McCormick argues that in order for a decision to be justified, a decision must first of all make sense in the real world. And a tribunal must first of all make an assessment of the consequences and to evaluate those consequences of the decision. So the tribunal in this case would, for example, say, right, well, the consequences of us considering immunity to be a matter which falls within our jurisdiction is that we may upset states. States didn't specifically include immunity in UNCLOS, but we're going to bring it within our jurisdiction. What are the consequences of that going to be? Or what are the consequences of the alternative? We believe that the consequences of the alternative, providing a partial answer would be less satisfying. We believe that that would be the worst outcome. This is the first part of justifying the argument, and this is something the tribunal didn't do at all. It didn't talk about what the consequences of its holding would be. But secondly, the decision, in order to be justified, has to make sense within the context of the legal system. And in order to do that, a decision must be both coherent and consistent. And in order to be coherent, a decision has to be justifiable by reference to a relevant legal principle which forms part of the legal system and that serves the values of the system as a whole. Again, here we can think about how the tribunal could have done this, right? The principle of effectiveness is a well-established and I would say not very controversial principle. The tribunal could have said that we want to accord greater weight or that we want to bring immunity within our jurisdiction in accordance with the principle of effectiveness, because giving a partial answer would lead our ward to be less effective in settling the dispute, right? Which is the point of what we are here to do, the values that we are striving to achieve. But again, the tribunal doesn't offer any of this sort of justification at all. And beyond that, a decision has to also be consistent. So the tribunal could have said, these are the consequences of what we propose to do, and this is the legal principle which supports what we want to do. But it also has to show that this does not clash with any valid binding rule of the legal system. Now, here we could, for example, disagree about whether this maybe impedes on a rule related to the consent of states, but I think there is ample scope for the tribunal to say that it was well within its rights in order to settle the dispute to adopt the position that it did. And beyond that, McCormick argues that we have to meet the requirements of formal justice. Rather, we have to make a decision which is generalizable beyond the facts of the present dispute. I would argue that this abbreviated reasoning that we got from the tribunal seriously gets in the way of us saying that the Enrica Lexie's dictum on this point is in fact generalizable beyond the present dispute. Okay, moving on to final thoughts then. I don't want to give the impression that any of this is to say that there is one right answer to any legal question. Of course, reasonable people may honestly disagree on any of the value judgments that are necessarily found at any step of the reasoning process that I laid out. And there is in fact no way of settling such ultimate disagreements through objective or rational means. Here we go beyond what is settled and we decide, and it was the job of the tribunal, in my opinion, to decide how we wish our international legal system to operate. Do we want, in, for example, cases of mixed disputes, certain things to be left outside the scope of the tribunal or to be brought in the name of effectiveness? Of course, legal decision makers have to, in concrete cases, make a decision and live with those consequences. And here we may find ourselves, as McCormick said, beyond what can be reasoned out, but we can get there for reasons. And I think it's important that in the future we explain our reasons more clearly. And I will stop there. Thank you.
Thank you very much, James, for that very informative talk. And I especially liked it, because many people criticize the findings of the tribunal on that point, but they do little beyond criticizing. So I did like that you gave some teaser as to how the tribunal could have dealt better, arguably, with that point. So thank you. As mentioned at the beginning, if there are questions, put them in the Q&A, and I'm sure James is very happy to answer them after all the presentations have been concluded. So without further ado, I would like to move to the second presentation, which will be held by Dr. Aaron Honeyball. And Aaron only very recently moved to Heidelberg, where he's currently a senior research fellow at the Max Planck Foundation for the Peace and the Rule of Law. It's quite a mouthful, so I had to look it up to be honest. But prior to moving to Germany, he was a senior research fellow at the Ocean Law and Policy team at the Center for International Law at the National University of Singapore. And prior to that, and I think we also met there, he was a PhD fellow at the Netherlands Institute for the Law of the Sea at Utrecht University. Aaron has published very widely on several issues of international law of the sea, including flag state jurisdiction, piracy. And Aaron will speak to us on, I think, primarily the tribunal's interpretation and application of Article 92 of the Law of the Sea Convention. And I think he's going to take a more negative take on that issue, because he said the possible unfortunate legacy of some of the general statements made therein. Well, I'm looking forward to hear those lines of criticism. So without further ado, Aaron, the floor is yours.
Okay, thank you, and good afternoon to you all. And thanks to the Institute. It's a pleasure to be here, to be part of the discussion today. Now, beyond the debate on the scope of incidental jurisdiction, the Enrica Lexie case is also fascinating as one of the first cases in which an international court or tribunal has explicitly conceptualized and applied the principle of exclusive flag state jurisdiction under Article 92.1 of UNCLOS. And today I'm not going to be using any slides. Hopefully there'll be no technical issues. As I'm sure you all know, Article 92 provides that ships shall sail under the flag of one state only, and save in exceptional cases expressly provided for in international treaties or the convention, shall be subject to its exclusive jurisdiction on the high seas. Now, the undefined jurisdiction in Article 92 of UNCLOS has stimulated differing interpretations upon whether this includes prescriptive and enforcement jurisdiction or purely exclusive enforcement jurisdiction. By prescriptive jurisdiction, we mean the authority of a state to make laws in relation to persons, property, or conduct. And by enforcement jurisdiction, we mean the authority of a state to exercise its power to compel compliance with law. Now, the majority of literature has previously suggested that the principle of exclusive flag state jurisdiction is only concerned with enforcement jurisdiction on the high seas or in the EEZ. But given the contrary pronouncements in the Enrica Lexie Award and the previous North Star judgment, an opportunity presents itself to revisit those conclusions. My argument today will be that the reasoning of the tribunal in the Enrica Lexie leaves much to be desired on at least two counts. First, due to internal inconsistencies in the award, the tribunal does not provide greater legal clarity on the scope of Article 92. This is because the tribunal adopts an overly broad interpretation of Article 92 within its conceptual restatement of the exclusive flag state jurisdiction principle, i.e. referring to exclusive prescriptive and enforcement jurisdiction, but then adopts a narrow interpretation of Article 92 in its application to the Enrica Lexie incident. And you've heard the facts in the previous discussion. So here it purely analyzes the legality of non-flag state enforcement jurisdiction. Second, the proposition that Article 92 refers to prescriptive and enforcement jurisdiction is still externally inconsistent with the interpretation of state parties as evident in subsequent practice and agreements, which clearly extend customary principles of prescriptive jurisdiction to foreign vessels and persons thereon on the high seas and the EEZ, without limitation and without the necessity of any concurrent treaty-based jurisdiction. No reasoning or evidence for the tribunal's contrary interpretation is presented in the award or the previous North Star judgment. So let us look at each issue in turn, and we'll begin with the tribunal's general interpretation of Article 92 before delving into the application to the Enrica Lexie dispute. So the tribunal's general interpretation of Article 92 is found in paragraphs 524 to 527 of the award. And after some brief statements on the fact that jurisdiction is often undefined and may refer to prescriptive, adjudicative, or enforcement jurisdiction, or a selection thereof, the tribunal states, paragraph 527, it follows from the above analysis that the principle of exclusive flag state jurisdiction under the convention is violated when a state other than the flag state seeks to prescribe laws, rules, or regulations over a ship of the flag state, or applies or enforces such laws, rules, or regulations in respect of such a ship. The arbitral tribunal also recalls in this respect the observations of IISTL in MV North Star that the principle of exclusive flag state jurisdiction prohibits not only the exercise of enforcement jurisdiction on the high seas by states other than the flag state, but also the extension of their prescriptive jurisdiction to lawful activities conducted by foreign ships on the high seas. Now, this is a very expansive interpretation of Article 92, which must be taken as obiter dictum because neither the submissions of Italy on Article 92 nor the response of India addressed high seas prescriptive jurisdiction. The question was one of whether India took enforcement measures against the Enrica Lexie while it was within India's exclusive economic zone. It also does not respond to the numerous dissenting opinions of the previous IISTL Provisional Measures Order, which suggested that UNCLOS, including Article 92, is silent on extraterritorial prescriptive jurisdiction concerning crimes such as murder at sea. Furthermore, the analysis in paragraphs 524 to 526 of the award do not examine Article 92 of UNCLOS itself. It is difficult to conclude how it follows from a general introduction to the concept of jurisdiction in international law that jurisdiction in Article 92 of UNCLOS must refer to both prescriptive and enforcement jurisdiction. As the tribunal highlights, jurisdiction is often not explicitly defined and, depending on the circumstances and context of each use, can refer to prescriptive jurisdiction, enforcement jurisdiction, or both. And tellingly, one of the general authorities on jurisdiction cited by the award was also cited in a 7-strong joint dissenting opinion to the North Star judgment to reach the opposite, more restrictive interpretation of Article 92, as essentially referring to enforcement. So in support of its interpretation of Article 92, the tribunal only refers to the North Star judgment. The support of jurisprudence, state practice, or subsequent treaties is absent. At least one of the authorities cited by the award in support of its interpretation of Article 92 has referred to the North Star judgment itself as appearing contrary to state practice. Likewise, neither of the current leading academic commentaries to UNCLOS adopt an expansive interpretation of Article 92 and instead treat it as one of enforcement. So following that tribunal's broad interpretation of Article 92 in general, it remained necessary to settle the parties' disagreement on application of UNCLOS to the Enrica Lexie incident. And it's evident here that Article 9 is relevant as part of the applicable law in respect of the parties' disputes concerning Articles 87, 90, 92 itself, and 97 of UNCLOS, as well as the application of customary prescriptive jurisdiction and the immunity of state officials. So we'll look at each one in turn. First, as per Italy's submission, the analysis of submission 2B concerning exclusive flag state jurisdiction only assessed whether any of the alleged conduct of India included an element of enforcement, which could then violate Article 92. The tribunal's application of Article 92 was thus much more restricted than its doctrinal restatement within its general interpretation. The tribunal also found Italy's physical interference in the navigation of the St. Anthony in the Indian EEZ without legal basis violated Articles 87 and 90 of UNCLOS. As this was physical interference attributable to Italy, this could have also raised a violation of Article 92, but this was not included in India's submissions and thus not discussed. So Article 92 also arose in the context of analyzing what jurisdiction India did have over the incident. India argued that its jurisdiction over the incident was not based on the disputed 1976 Maritime Zones Act and 1981 notification, but rather the territoriality principle and the passive personality principle. So the tribunal accepted that the objective and subjective territoriality principles apply to vessels so that a flag state's prescriptive jurisdiction may extend beyond the vessels to related acts initiated or concluded extraterritorially. This includes acts aboard foreign flag vessels on the high seas. And I quote, "Where an offence was committed on board one vessel and completed on board another vessel, the flag states of both vessels may have concurrent jurisdiction over the incident." Now, this is surely correct, but such customary law prescriptive jurisdiction is not codified in any treaty and is not what Article 92 of UNCLOS envisaged as exceptional cases expressly provided for in international treaties or UNCLOS. This should be evidence alone that Article 92 is not concerned with prescriptive jurisdiction at sea, and claims to the contrary might run the risk of muddying the water and legal certainty. Such ambiguity is then evident in the next paragraph, number 368, where the tribunal refers to the principle of exclusive flag state jurisdiction as providing exclusive jurisdiction to India in respect of the St. Anthony and exclusive jurisdiction to Italy in respect of the Enrica Lexie. So had the tribunal limited the concept of exclusive jurisdiction to one of enforcement jurisdiction at sea, This statement would certainly clarify that the previously recognized concurrent prescriptive jurisdiction over a transnational offense does not affect the exclusive enforcement jurisdiction of each state concerning its vessels. There is no express exception that would allow, there's no express exception to the exclusive flag state jurisdiction in respect of the crime of murder, so neither state could take non-consensual enforcement measures at sea against any foreign vessel involved. Instead, the tribunal's statement that exclusive flag state jurisdiction concerns both prescriptive and enforcement jurisdiction results in a series of paragraphs which suggest prescriptive jurisdiction over a vessel can be simultaneously concurrent and exclusive, which directly conflicts with the ordinary meaning of these diametrically opposite terms. The same confusing position is on Article 92 is then found again in the discussion on immunities in paragraphs 871 to 873 of the award. So as a side note, it's also worth noting that while India's assertion of the passive personality principle was not addressed because it was not necessary, this customary principle of jurisdiction has witnessed use across a variety of states. And while the scope of the offenses to which it may be employed is unsettled, there is no real question anymore that such a basis of jurisdiction exists in international law. Neither state in this dispute has objected to its existence outright, and other previously skeptical states, such as the USA, now exercise passive personality-based jurisdiction, explicitly including the murder of a US national aboard a foreign vessel, the facts of this case. Multilateral instruments, such as the ASEAN Convention on Trafficking in Persons, also refer to the possible use of the passive personality principle against all offenses under the instrument, period. There is no suggestion in state practice that I'm aware of that any state limits its exercise of passive personality jurisdiction to exclude offenses on foreign vessels due to any exclusive jurisdiction principle. And this makes sense. I mean, today the major flag states are not the major labor supply states of merchant shipping or fishing vessels. So if we want to provide greater protection to persons working at sea, we should be embracing concurrent jurisdiction to maximize the venues and responses available, not imposing restrictions or uncertainties through a broad interpretation of Article 92. So turning to the discussion on Article 87, the tribunal confirmed that Article 87 protects a flag state's vessels from unlawful exercises of prescriptive jurisdiction by non-flag states on the high seas or within EEZs. As confirmed in the South China Sea arbitration, Article 56 of UNCLOS would also protect a coastal state's jurisdiction over vessels falling within its exclusive EEZ rights and jurisdictions from the unlawful exercise of prescriptive jurisdiction by non-coastal states within its EEZ. Now, the freedom of the high seas is an interrelated but distinct principle to that of exclusive flag state jurisdiction. As the latter is a component of high seas freedoms, Article 87 of UNCLOS is implicitly broader on the matter of jurisdiction at sea, so as not to be superfluous. The award unfortunately appears to blur this boundary by reiterating that Article 92 codifies a long-standing customary principle that, and I quote, apart from certain special cases which are defined by international law, vessels on the high seas are subject to no authority except that of the state whose flag they fly. In virtue of the principle of the freedom of the seas, that is to say, the absence of any territorial sovereignty upon the high seas, no state may exercise any kind of jurisdiction over foreign vessels upon them, end of quote. Now, this is a direct reference to the Lotus judgment, and it is the same sole precedent cited in North Star to support its reading of Article 92. However, the tribunals in both cases did not highlight that the Lotus judgment here was likely discussing at-sea enforcement jurisdiction. On prescriptive jurisdiction, the PCIJ then stated that it by no means follows that a state can never in its own territory exercise jurisdiction over acts which have occurred on board a foreign ship on the high seas. This caveat was not addressed. What is more, if jurisprudence predating UNCLOS is considered, the Muscat Dow's case appears informative on the general approach to prescriptive jurisdiction at sea. The tribunal's starting point in this case was that the legal situation of vessels flying foreign flags and of the owners of such vessels was determined by the general principles of jurisdiction, by the capitulations or other treaties, and by the practices resulting therefrom. While a bilateral treaty had limited enforcement jurisdiction in the territorial sea in this case, this expressly had no consequence for the exercise of nationality-based jurisdiction by the Sultan of Muscat over owners, masters, or crew members of such foreign vessels. So Enrica Lexie also arises in the context of Article 97. And here, Article 97 was previously argued that the necessity for and existence of Article 97 was testament to the fact that exclusive flag state jurisdiction concerns enforcement and not prescription. The tribunal recognized that the international community, through Article 97 and its predecessors, has reserved exclusive penal jurisdiction in matters of collision or any other incidents of navigation to either the flag state or the state of which the accused person is a national. The tribunal stated in paragraph 646, and I quote, "It is thus apparent that an exception to the otherwise prevailing rules on allocating jurisdiction was created specifically for its situation where the master or another person in the service of a ship are at risk of facing penal proceedings before foreign courts in respect of navigational conduct on the high seas." This clearly interprets Article 97 in the context of general international law on allocating prescriptive jurisdiction, and not any exclusive flag state prescriptive jurisdiction as a starting point. This is then an implicit application of the restrictive interpretation of Article 92, despite the tribunal's previous explicit statement supporting an expansive interpretation. As argued by India, Article 97 of UNCLOS leaves intact the position of the Lotus judgment in respect of criminal prescriptive jurisdiction at sea, beyond those cases of collisions or other incidents of navigation. And so today I've basically tried to highlight the internal and external inconsistencies of the Enrica Lexie Award in treating exclusive flag state jurisdiction as including prescriptive jurisdiction. A contextual interpretation of Article 92 and an examination of the drafting history, which have been discussed elsewhere, also suggests Article 92 concerns purely enforcement. Now, for those of you who are more practically minded, an inherent danger of internal divergence is that conflicting reasoning may result in a matter remaining unsettled, possibly resulting in continuation of disputes generally. And I think the 1927 Lotus reasoning on extraterritorial jurisdiction is testament to this, because discussions of jurisdiction today still always begin with the debate on whether the prohibitive rule or the permissive principles approach is correct, despite the lack of state practice supporting the unlimited unless prohibited approach. External divergences with state practice and reasoning may raise practical concerns, such as trust in courts and tribunals, faith in their interpretation, the loyal implementation of their judgments, and the possible fragmentation of international law concerning identical facts. Notably here, the law of the state jurisdiction and the law of the sea. More broadly, unclear reasoning may prolong or aggravate other disputes relating to exclusive flag state jurisdiction. And then finally, legal uncertainties are detrimental to state practice and efforts to protect the marine community and the marine environment. Urbina's damning expose in The Outlaw Oceans highlighted the often exacerbating lack of political will for international cooperation and enforcement concerning crimes that have been committed far from shore. Likewise, when we're addressing entities involved in emerging maritime concerns with a nexus to the state, state responses should not be unnecessarily complicated by expansive interpretations of Article 92. It would thus be very unfortunate if the North Star judgment and Enrica Lexie Award begin to have a chilling effect on the extension of perfectly valid customary law prescriptive jurisdiction to activities involving foreign flagged vessels. The same may be said of any chilling effect on ongoing multilateral negotiations, such as the draft BBNJ agreement, which is currently rather light if you compare its measures against vessels flying the flag of non-parties, to previous implementing agreements, such as the fish stocks agreement. And on that very happy note and the 20-minute mark, I think I shall conclude. Thank you.
Thank you, Aaron, for sticking to time so excellently, and also for your very thought-provoking presentation. And I'm sure that you take a very critical view, so there should be some in the audience who might have a different view. So hopefully, and once again, to repeat myself, if there are questions, please put them in the comment box. And I'm sure this gives food for further discussion. But prior to moving to the discussion, I want to move now to our final speaker, Professor Maria Gavunelli, who is Professor of International Law at the University of Athens. I have to cherry pick from her CV because it's rather extensive and quite impressive, but she has published very widely on very different issues, including law of the sea, energy, environmental law, but also migration issues. Well, in that vein, she has published several books, both in Greek and English, amongst others, on installations, functional state jurisdiction. And in addition to that, she's also a visiting professor at a number of universities and research institutions around the world. I think I will stop there and just hand over the floor to Maria. So the floor is all yours. Thank you.
Thank you so much, Yuri. A wise decision. Thank you to the Institute and all of you for the most kind invitation to discuss the after effects of Enrica Lexie, because this is my reading of the situation. And I must say that James and Aaron have actually touched upon the issue so thoroughly that there are very few things that are left to me to comment on, which means that I'm not going to attempt to do so. What I'm going to do is take a step back and have a look at the Enrica Lexie situation as a whole. Comment number one, what a story. One could easily see a mini series or a major film for Netflix. The particulars of the case are really quite numerous and exotic enough, I think, and adventurous enough to guarantee an audience. But in addition to this wider cinematic audience, I wonder whether there would be a legal audience to follow. And the question is, and the reason really is very, very simple. Major awards, major decisions coming from international courts and tribunals remain in our memory when they do something very well, or when they do something very bad. The in-between situation is really delegated to a footnote. The question in the Enrica Lexie situation is really, if that decision, if that award was not in place, we would have been better off or worse off. And I think that on most accounts, the Enrica Lexie situation has not really clarified the issues. So I'm really moving towards an answer that says it wouldn't really matter. Let me explain. First, on the question of incidental jurisdiction. There's no question that the tribunal was perfectly aware of the fact that there was a dispute before it, and it was also aware of the fact that there might have been a real question behind that dispute before it. It is no accident that it refers to the South China Sea arbitration and the fact that one has to seek the real question. With respect, however, I believe that here there was a clear-cut dispute. There was no reason to go behind it to have a look at the real question. There were enough elements emanating out of the Law of the Sea Convention without really going beyond that. What we take out of the paragraphs on the incidental jurisdiction, James has really walked us through them very, very quickly and very, very thoroughly indeed, in an excellent exposition. I would just make a couple of points. Point number one, there is no question that the essential element in all these adjudication processes is actually the consent of the state. The tribunal in this case has tried to balance out the required consent of the state with the effectiveness of resolution of a dispute. The consent was put in the parameters, not only in this case, but generally speaking, the law of the sea, in the parameters of Article 288, the gatekeeper, compromissory note as a compromissory clause as a gatekeeper of the consent of the state. That is perfectly true. That was the real case in the South China Sea arbitration. That was the reason why in the Mauritius case, the Chagos arbitration, the tribunal took pains in trying to figure out exactly the parameters of its jurisdiction and suggested there in what is a famous phrase, and James referred to that its jurisdiction extends to making such findings of fact or ancillary determinations of law as are necessary to resolve the dispute presented to it. There are indeed two parameters here. Again, James was very right. A question of ancillary and the definition thereof, and the question of necessity and the definition thereof. In my mind, necessity is the reverse of the Norwegian loans situation. You cannot proceed if certain elements impact upon third parties. On the other hand, you cannot proceed unless some elements are present in these circumstances. In the Enrica Lexie situation, the tribunal focused on these necessary elements and concluded that it had to proceed taking into consideration all elements of the case, including immunities. It forgot entirely to talk about ancillary matters and the question and the definition of these ancillary matters. In the Ukraine-Russia arbitration, it was made very, very clear that the question of jurisdiction on the basis of sovereignty is not a minor issue. It's not an ancillary issue. It's actually the main issue. And being the main issue cannot be discussed in view of some other justification. To a certain extent, this is what the South China Sea Arbitral Tribunal has also done. They have tried very, very carefully to talk about entitlements rather than sovereignty, trying exactly to shoehorn, to use the phrase of one of my dearest colleagues in this respect. Why have they felt in the Enrica Lexie case that effectiveness had really could move beyond consent? Because I sensed this kind of freedom behind this particular award. Was it because the parties, India and Italy, were on generally friendly terms? Was it because they were so further apart that no real conflict was really possible in terms of armed conflict? Was it really a sense that, oh, come on, this is a minor situation that needs to be addressed and let's address it? I don't know. But I do have a sense that the tribunal was not as careful as they would have been if that were another case. If instead of India and Italy, it were India and Pakistan, for instance. Neighbors, in other words, and neighbors always have a history. So would I take that case as a precedent if I were to talk incidental jurisdiction in a new case that might crop up before international adjudication? Not really. Or at any rate, I would try and distance myself from the rather, how should I put it diplomatically, not well thought of sentences that are found in this particular award. I don't think that there has been particular attention being paid to the ramifications of that case beyond the particular case. Granted, I'm entirely with you that each case before each court or tribunal is a casus unicus. There's no question about that. But still, we all need to have an eye towards the future and see whether that works or not. A minor point here in the incidental jurisdiction question. I would have bought the Italian argument that immunities are also included in the discussion of the law of the sea, to be very frank. Why? Because immunities are there, immunity of ships, admittedly. In the Ara Libertad case, Italy's had to deal with that as well. But they come along with general international law. I wouldn't have any major problems encompassing that or viewing such rules in light of the law of the sea convention. This is something that is usual in international adjudication. This is something that courts and tribunals are usually well versed in dealing with. So I would certainly really need to have a look at that again. The tribunal tried to be very, very clear to a certain extent, and therefore felt that they had to go into the substance of the immunity discussion to further decide on the territoriality principle. Again, I can live with that. I don't see any major issues here, but I just state my preference for this easier, so to speak, approach. A second point. Aaron was very correct in suggesting that this is the first case that deals with the exclusivity of flag state jurisdiction under Article 92 of the Convention, which is surprising, of course, isn't it? Because this is such a fundamental principle, and one would presume that it would have been something more in terms of international adjudication. On the other hand, because it is such a fundamental principle, there were very few disputes arising from it so far, and those that are quite old and far away. There is, however, a point here, and the point is that the way Article 92 is drafted, one could be excused of considering both prescriptive and enforcement jurisdiction as part of Article 92. When I first read these articles many, many years ago, my immediate reaction was that, yes, it is all inclusive, isn't it? And it was only upon second thoughts when I realized what was lying behind it that I said, hold on, let us have a look at that. Aaron is entirely right that the full force of customary law, state practice, the literature really goes to enforcement jurisdiction. But this is not what Article 92 says. So it might be interesting to really have a further look on it. And in that respect, it is a pity that the Enrica Lexie tribunal really didn't manage to give us a definitive reading of Article 92. That is particularly important, and Aaron alluded to that, because again of possible ramifications for the future. Imagine a situation of business and human rights. Imagine prescriptive enforcement on labor laws upon the crews. Imagine the repercussions for BB&J. Aaron referred to that, and the ways we're now going to expand our activities in the high seas. I would suggest that sooner or later we need to revisit 92 and start clarifying the situation, perhaps explaining in very clear terms that we're talking about an exclusive enforcement jurisdiction, but we're talking about a concurrent prescriptive jurisdiction. And that particular tribunal has really failed to do so. The question is very clear. If that award was such a failure, what are we doing discussing it? Well, we're discussing it because it was an excellent opportunity to move on, to move ahead, to clarify issues. And we are concerned because it failed to do so. It failed to do so in the incidental jurisdiction case. And in that respect, I don't think that there was any major harm done. It is irrelevant. Next time around, somebody else is going to decide on what is incidental or not. At the end of the day, it is a decision that has to be made on a case-by-case approach. The harm, I think, is greater in respect to exclusive flag state jurisdiction, simply because in these circumstances, and this being the first discussion of the issue in a very long time, it gives the wrong signal. It allows, to a certain extent, it gives leeway to further restrictions in terms of prescriptive jurisdiction. And that could develop into a problem in the very near future. I would stop there, and I would gladly see questions and looking forward to the discussion between ourselves as well. Thank you so much.
Thank you, Maria. My hand raising was not to indicate that you had to stop. I was just trying to, because I think Professor Natalie Klein raised her hand, but I think we can't get you on speaker. So if you do have a question, please put it in the comment box, because I think the format doesn't allow us to hear you speak. So if you do have a question, please put it in the comment box. And Maria, thank you very much for reflecting on the Enrica case more broadly, because I think I would be interested to hear whether, because I think you raised a question which struck a chord with me that, okay, are we better off or worse off with the Enrica Lexie case? And I would like to, perhaps if James or Aaron has some views on that, because you think about the legacy, is it mainly a more negative one, or are there also some positive takeaways to be had from the Enrica Lexie? James, Aaron, any views on that?
Yeah, I would be happy to start. I think my reflections on this are rather off the cuff. I have the impression that this is, I mean, in the grand scheme of things, a relatively minor dispute, right? Not to minimize the loss of life that occurred, for example, but we're not talking here about, I don't know, the ICJ's nuclear weapons advisory opinion, right? Or any environmental litigation on the future of the world. It's, you know, it was one incident which happened on one day, and I think that the award, much like that, won't live long in the memory. I have chosen one particular thing that I thought that the tribunal could have done better in the award, but the award itself is a mammoth. We should say it's huge. It's 300 odd pages, I think. And I think there are certain things that the tribunal has done relatively well, particularly from a fact-finding dispute perspective. Sorry, I don't think that the tribunal could have been accused of shirking dealing with the facts. I mean, the award goes to great lengths to recite the different factual submissions made by both parties. And in relation to certain legal issues, the tribunal does take these very seriously. I thought Maria's point was really interesting on why maybe the tribunal felt that it could be, had a bit more license to emphasize or give more weight to effectiveness rather than state consent here. That, you know, maybe there's no chance of armed conflict breaking out between these two states. However, that does trouble me if that isn't the case, because this thing that I mentioned of formal justice, of there being a requirement of us making generalizable legal decisions, I think that would fall foul of that. I don't think we can have one rule for dangerous cases and one rule for states who get along.
Thank you. Aaron, I think you also wanted to comment.
Yes, just very briefly, I think Article 92, not a great incidental, there's a debate, but I think there are a lot of positive contributions in the award. If you look at it from a practical perspective, the amount of progress that was made between the incident and the filing of the case was very small. But then subsequent to the award, we now have this decision of the Indian Supreme Court, which establishes that, okay, the amount of compensation was agreed between the parties and paid. India has now stopped exercising criminal jurisdiction, and India and Italy will cooperate in the Italian investigation and possible criminal prosecution. So apart from that Italian investigation, the incident has basically been brought to a close. And then on the legal merits, I don't like the Article 92 debate so much, but there are a lot of interesting contributions. And Bundy, who worked for one of the team, was at an event last week in Singapore and mentioned one about the tribunal's assertion over the court proceedings. So it was the tribunal that was inviting these witnesses itself to elaborate the facts. And that's why we have so much information. And then just on the legal issues, I think, the tribunal's analysis of Article 87 went much further than the North Star. It looked at the consequences of recognizing subjective and objective territoriality. We have a bit of analysis on the duty to cooperate in piracy and the fact that India was a contracting party to RECAP, so sharing information on incidents in the region, effectively discharged that duty to cooperate. And then we have a bit of elaboration on what incidents of navigation mean, and recognition that this can involve ocean users beyond vessels. So they point to the possibility of damaging submarine cables, which, is a user of the ocean that doesn't get much attention, especially in case law.
Thank you for both your insights. I'm not going to disabuse my position as a moderator further to ask any questions. I'm just going to turn to the Q&A. I assume the panelists can see it as well. I think first question by Dr. Henrik Ringboom is addressed to Aaron. Do you completely agree with your assessment I completely agree with your assessment of this case and on the interpretation of Article 92, paragraph 1. But have you come across any explanation for the confused position in the Enrica Lexie Award? Is it just ignorance, or have you found something else that could justify the sweeping general statements made in paragraph 524 and beyond that?
Yeah, well, so I mean, like all legal principles, this is open to debate. You know, I will take my position until I'm proved otherwise, and then immediately, I mean, if I'm given good evidence, I'll switch my position. And yeah, obviously we weren't there in the room, but I think the importance is that, you know, judicial decisions are sometimes a compromise among the tribunal members, and so it may eventually the decision will reflect possible differences between those members. So this might be why internally there are some inconsistencies, or it might be why they use broad language which is open to different interpretations so that everyone can agree to the text of the award. And then there's a simple fact that courts and tribunals are rarely asked to rule on clear-cut legal questions. So I think that's why we have these broad statements being made, and then on application, perhaps they were more strict on how they apply the convention to the case. But that's pure speculation.
Yes, thank you, Aaron. I think the other question is directed at Maria. Sorry, Natalie, I didn't want to put you on the spot, but I really thought you wanted to ask a question. But she's wondering about Maria's comments on the Lexie Convention referring to vessel immunity, and that could have been a way for the tribunal to address the state official immunity question. And she asked how so. I wasn't sure if this suggestion was to align with Article 293 of the Convention. Past decisions have been problematic in expanding subject matter via that article. It seems incidental jurisdiction was preferable as a rationale for expanding jurisdiction beyond Article 293. So do you have any thoughts on that?
If I may, Natalie, you're entirely right. No. I did not suggest for a moment that the official state immunity would actually be confused with vessel immunity or anything like that. My point is really that the Law of the Sea Convention is not unaware of immunity issues, and it includes a specific immunity issue that has to do with vessels. Yes, I entirely agree with you that the incidental jurisdiction avenue was the preferable rationale for expanding jurisdiction. There's no question about that. I only pointed out that I would buy Italy's argument on leading into that expansion, and I found that easier to understand. And I find also that this works well with the nature of immunity, which is really a bar to jurisdiction, isn't it? So first you say that you do establish jurisdiction, and then you look for exceptions to jurisdiction, and therefore then you need to go into the immunity question. It is reasonably clear in my mind, and I think that to a certain extent the tribunal did well. I would simply have preferred an easier way of approaching it rather than anything else. Indeed, if I may comment at that point, I think the most important good point out of that particular award, and indeed the whole discussion around it, is the fact that this was dispute settlement. A dispute was actually settled. The parties really conformed. They enforced all the awards, the preliminary measures as well, and everything. They have paid the compensation. They have worked together. So the purpose was really achieved. And in such, we need to congratulate all those involved in actually resolving a case, which is not to be taken for granted in the law of the sea and elsewhere in international law. Thank you.
Thank you for that response, Maria. I think we have to, for the questions, we still do have some time. So like I think the panelists are able to see the questions. So Etifimios is asking, he has two questions. So one is about subjective territoriality or objective territoriality of vessels. And he asked whether that is not a very outdated conceptualization of territory.
It is.
Yes, please go ahead if you want to respond to his inquiry.
We have an ongoing research project, incidentally with IISTL, that has to do with the idea of borders and jurisdiction and sovereignty beyond borders. What constitutes a border, and therefore what is the element of sovereignty, and therefore what are the links to sovereign power, and therefore what is territory and what is not. And that would have an immediate impact, for instance, in migration issues. Do you need to knock on the border to request protection under the Geneva Convention or not? I don't want to move into that, but the short answer is yes, this is a very dated conceptualization of territory, and we need to start thinking beyond that. Need I have to mention cyberspace? I think not. Thank you.
James or Aaron, do you want to chip in on this question?
Yeah, just a minor point is like, I think maybe the tribunal was here. Here, the tribunal was quite good in not providing too much reasoning, because I mean, we had this debate for a long time. What is the basis of flag state jurisdiction? And the tribunal did explicitly reject floating territory as the basis, but then that you can apply the territoriality principle in these variations. So it's kind of akin to territory, but it's definitely not territory, but it's akin to territory.
Yes, thank you. James, I think have you seen the last question which is directed at you from K Song? Have you?
Oh, yeah. So thank you very much for this question. I think it's a really fascinating one about how to assess the sociological legitimacy of certain controversial decisions. Now, of course, my comments were limited to thinking about legal reasoning as a form of practical reasoning and the function of legal reasoning to persuade. And the general argument being that in order to persuade, we need to justify what it is that we do. And so I think the reception of decisions is intimately linked to that attempt to persuade through reasoning. And I think that I would say that states have many different fora in which to make their views known about international law, right? They can do so in the General Assembly, they can do so through their unilateral statements, they can do so through the ILC. So I wouldn't like to think too much about creating a forum, for example, to discuss the reaction of states to certain awards. And I think, while of course legal decision makers have to, as part of the process that I laid out, think about what the consequences of their actions will be, I don't think that it should be the forefront of their minds in that sense. It shouldn't be the overriding consideration, seeing as tribunals, as I've said before, legal decision makers have to do justice according to the law, and what they do, their discretion is limited also by the law and not just by the policy preferences of states.
Yes, I think there's another question if you want to spend a bit more time talking. Natalie does ask about give me your comments on the role the tribunal played in Enrica Lexie. Do you think that's consistent with the perceived role of other Annex 7 tribunals or IISTLs? Or do other decisions align better with McCormack's views on the judicial function? So how operational was Enrica Lexie in that regard across unclosed dispute settlement?
I think this is again a really good question, and one that I'm glad was asked, because yesterday I was attended a presentation about Mauritius Maldives, and then we had this discussion about the legal effect of advisory opinions of the ICJ. And there, I think that you have another very poorly reasoned legal decision, and there again, I think we're somewhat left wanting. I'm not sure I'm particularly well placed to give an assessment across the board, and I think that would be simplistic. And I would just maybe go back to what I said before when we were asked to consider the legacy of this case, and I would say once again that I do think there are, in this huge 300-page award, parts which are stronger than others in that sense. And of course, it is our job as academics to pick at those bits that we think have not been done very well, in order to try to hopefully avoid such mistakes in the future.
Yes, well, with an eye to the time, I think there's some more questions, but I don't think we're going to be able to address all of them. I think we're to address to Aaron. Perhaps you can give a very brief answer, because then I do want to give the three of you the opportunity to give some concluding thoughts, and I've been informed that we have to really conclude at 2:05. So Aaron, just perhaps a few thoughts on the, I assume you have seen the question in the chat.
Yeah, and I think my answer can also just be my concluding thoughts. Yeah, I think you raise a very interesting point, and I think this is good evidence, again, that is referring to enforcement. So when we talk about treaties that are providing for interdiction at sea, and Marie and Akis will know far more about this than me, but these are very narrowly interpreted when they apply, and they are subject to very strict procedures and only apply among parties, i.e. they are an express exception provided for. When we look at these other treaties that are providing for prescriptive jurisdiction at sea, or hinting that it should be used as an obligation, these are not limited to among parties flagged vessels. So in that sense, you do not have an express exception if you apply this to a non-contracting party vessel, and therefore there's evidence therein that, yeah, Article 92 is not really doing anything with prescription. If we want to restrict prescription that doesn't have a legal basis, we can look to Article 87 on the freedom of the high seas, and this is recognized in North Star and Enrica Lexie. So we don't really need Article 92 in these cases. Thank you.
Thank you, Aaron. So Maria or James, any concluding thoughts before I bring this session to an end? No?
One final point, really. James mentioned the fact earlier that sometimes tribunals adjust, to use a kind word, to the disputes before them. Reality, it is so. And we need to take that into consideration and somehow inform our decisions on that. After all, law is based on reality, among other things, international law more than anything else. So thank you so very much.
Yes, well, thank you. Well, actually it's 2 o'clock, so I think it's very punctual, would be a very punctual end to this very interesting webinar. So many thanks to Maria, James, and Aaron for such excellent presentations, and to also hear the broader thoughts on these issues. Also, my thanks to all the people who have joined, and quite a few have joined. So thank you for participating, and hopefully we will see each other again somewhere in the future. So thank you, and have a good afternoon. Thank you.
Thanks, Yuri. Thanks, everyone.
Thank you, James.
Thank you, everyone. Thank you.